Welcome to U-Counsel. Slip and fall injuries are quite common. There is a lot of litigation that happens because of persons who have been injured due to a slip and fall. There have been some significant changes to the legislation with respect to slip and fall injuries, and we will discuss those changes in today's lecture. We begin with our usual disclaimer that this lecture is not legal advice. If you have any specific questions regarding your own issues, you should contact a lawyer or paralegal or the Law Society of Ontario for a referral. So there is a specific kind of injury that we are discussing today, and that injury is caused by snow or ice, which is commonly called a slip and fall injury. And with respect to these kind of injuries, the person who is injured has an ability to sue the occupier for damages. What is an occupier? It is defined in the Occupier's Liability Act. And an occupier is a person who has the physical possession of the premises on which the person was injured, or has the responsibility for or control over the condition of those premises or activities, or has the ability to control the persons who are allowed to enter those premises. So it's quite a broad definition of an occupier. And commonly in this definition, what would include would be a municipality, for example, which is responsible for maintaining public roads and sidewalks and bridges. So municipality in those circumstances will be considered an occupier. Homeowners, business owners, landlords, tenants, and independent contractors who are responsible for removing snow or ice from certain premises. So this is a non-exhaustive list, but it gives you an idea of who could be an occupier. And just so you know, a tenant could also be considered an occupier, and it will depend upon the terms of the lease that the tenant has signed with the landlord. So what are the changes with the limitations period? Previously, so when this legislation did not come into force, if you are suing a private party, not a municipality, not a governmental entity, then you had up to 2 years from the date of incident to commence your court action for damages arising from that slip and fall. And 2 years is the normal limitations period under Limitations Act. Now, if you were going to commence a court action against a municipality for damages, then the legislation under Municipal Act required that you had to serve a notice on the municipality within the 10 days of the incident, within the 10 days when the person slipped and fell. Now, a lot of people do not know this, but at least the lawyers who deal in personal injury, they know quite clearly that if you are intending to commence a court action against a municipality, you have to serve a notice within 10 days. Otherwise, you may lose your ability to commence a court action against a municipality. So that was the previous regime. Now, what has changed is the change is with respect to the private parties. So from 2 years, the time limit has come down to 60 days. So within 60 days of the incident, of the day when the person fell, that person, the claimant, must serve a notice on the occupier about that particular incident that they intend to commence a court action. So they have to serve a notice within 60 days. And if they don't do that, then they may lose their ability to seek damages. Now, with respect to municipality, there is no change. The 10 days limitation periods remains the same. But with respect to private parties, which is a large component of these slip and fall court actions, the time limit has changed from 2 years to 60 days. What happens if you do not give notice? In certain circumstances, it is not a problem. So it is 60 days notice requirement is not a complete bar, but there are specific circumstances in which that notice requirement may be waived. The first circumstance is when the person who is injured dies as a result of the injury. And if that is a situation, then a 60 days notice requirement may not be necessary. Now, another circumstance is where a judge is satisfied that you have a reasonable excuse why you couldn't serve your notice in 60 days, number one. And then the second component is, and the defendant is not prejudiced in its defense. So what that means is, if the defendant had an opportunity to gather all the relevant evidence, if you had given the notice within 60 days, and the defendant has lost that opportunity and will not be able to sufficiently defend itself, then the court may say, even though your reason is justified, there is a significant prejudice to the defendant, and therefore we will bar this court action. But the point here to note is that it is important to recognize that there is a significant change. We are into the winter season, and as it happens in the winter, there are a lot of people who suffer these injuries because of slipping and falling on snow and ice, and it is important to know the change in this legislation. If you want to learn more about it, I've provided the link to Occupiers Liability Act, which is the fundamental legislation that deals with occupiers' liability. And Bill 118 has been passed, and the changes are effective as of early December. Thank you for watching.